Attorney Rusty Messer coming to you from Baton Rouge, Louisiana. Today we're going to talk about how bail gets set and modified in a Louisiana criminal case. Now let's get our terms straight. Bail is the amount of money or property that the court wants to hold in order to allow someone to be released from jail. A bond is what actually gets placed with the court. When a court is setting bail, it is supposed to consider some factors. One is the charge against the person, and that's usually what they were arrested for. Another factor is the evidence against the person. Now early on, that's usually just a preliminary police report. They're supposed to consider the suspect's criminal history, prior arrests, prior convictions, things like that. The suspect's ability to pay, that's how much money or property could they come up with. Whether the suspect poses a danger to anyone in the community, whether the suspect had any drugs on them at the time of arrest, whether the suspect has any pending criminal charges, and then there's what I call the catch-all factor, which is that the court can consider anything else it thinks may affect the likelihood of the person to show up at future court dates. Now, once bail gets set, it can be modified a couple of different ways. If a person bonds out, then they later miss a court date and get a bench warrant, or they get arrested on a new charge, the bail can be increased or revoked. Conversely, if some new evidence comes to light in favor of the defendant or some of these other factors change, the defense attorney can ask for the bond to be, or for the bail to be lowered. Now, either one of those requires a motion filed by an attorney, and it has to be heard in court. If you'd like to learn more, please request a copy of my book, Surviving the Louisiana Criminal Justice System. It's available at www.louisianajustice.org. Go in there, put in your information, and we'll be happy to send you a copy that's available to the next 25 people that respond.